Hi, my name is Dan Chambers and I'm the founder of Chambers Law Firm. This video is the next in a series of videos that I've done to help you understand the criminal court system, criminal procedure, and the process that's involved in your misdemeanor or your felony case. In previous videos, we spent a lot of time talking about the differences between misdemeanors and felonies, the various stages, and what you can expect in your case. Today I'm going to use kind of an all-inclusive topic that covers both misdemeanors and felonies, and it deals with what's called speedy trial rights. I'm going to tell you about the time limits involved in a misdemeanor case and a felony case. Now, at the outset, I want to be very clear that all of these time limits are subject to what's called your right to waive those rights. In other words, if you want to take longer, or if you don't want your case to move as quickly, or if your attorney says we need additional time, you as the defendant can always waive these rights. But this video is designed to tell you what those limits are so that you know whether you should waive them or not. Let's start with misdemeanors. If you're in custody at the time you're arraigned, and remember we talked about the arraignment being your first court hearing, if you're in custody, your trial must take place within 30 days of your arraignment. If you're out of custody at your arraignment or that first court hearing, your case has to be brought to trial within 45 days of your arraignment. Those are called your speedy trial rights. If the prosecution is not ready for trial, or if the trial doesn't take place within those time limits, the case will be dismissed. In fact, it has to be dismissed unless you agree to waive those time limits. So again, it's a very important decision that you need to make about whether you should waive them or not. Let's talk about felonies for a minute. Felonies are different because they have different procedures involved. First of all, if you remember, we talked about what was called the preliminary hearing, the prosecution's snapshot of their case. In a felony case, once you're arraigned on that felony complaint, that hearing has to take place within 10 court days, and at the outside, 60 days from your arraignment. So in other words, that preliminary hearing can't go on forever. It has to take place within those time limits unless you agree to go beyond them. Let's talk about your trial rights. Now, after your preliminary hearing, if you'll recall, I told you there'd be a document generated called a felony information, and you get arraigned on that as well. Now, once you get to that stage and you're arraigned on the information, your case has to be brought to trial within 60 days of the arraignment on that information. Again, if the prosecution is not prepared for trial within that 60-day period, and you don't agree to let it go longer, your case has to be dismissed. But here's an important thing for you to remember. In a felony case, the prosecution has the opportunity to refile it one more time to try to get it right and try to get the trial off the ground. But those are the basic rights that you have and the time limits they have to occur in. I hope that this video has been helpful and informative. And more than likely, you still have questions that you'd like answered. We at Chambers Law Firm pride ourselves in effectively communicating with our clients and trying to answer all of their questions about their cases. Please feel free to contact us with any questions or concerns about your specific situation. For prospective clients, we always provide a free consultation, and we have Spanish speakers available to assist you if necessary. Thank you for watching.